Well, the size is really somewhat irrelevant. The key thing is whether or not the business can fund a Chapter 11 plan. The plan does have to satisfy a few requirements. And if the debtor can propose a plan that satisfies those requirements, then it doesn't really matter whether it's a big business or a small business. To think in terms of extremes, GM filed a Chapter 11 some years ago, and they were one of the largest companies on the planet. On the other hand, I filed Chapter 11s for very small businesses, one in particular that's currently pending where there are 2 shareholders. So there really isn't a size limit on the size of the business that can file for Chapter 11 protection. Now, there are subsets of Chapter 11 dealing with special cases such as railroads, but in general, there really aren't restrictions. The key thing is whether or not the debtor can propose a feasible plan of reorganization. And one of the important factors that comes into this is if the debtor's assets exceed the value of the debts, well, then unless the creditors accept a different treatment, the debtor's going to have to pay those debts in full, spread out over time, of course. So if they are not as much as in value as the total debt, then the debtor may be able to pay significantly less than the total of the debt. The key thing, of course, is getting the creditors on board. And so what I have alluded to here, if I can make it a little bit more precise, is something called the Chapter 7 liquidation requirement. Now, if a business files under Chapter 7, it's shutting its doors. It's closing down. A Chapter 7 trustee is appointed by the court to liquidate all of the assets, and the proceeds are distributed to the creditors on some sort of a pro rata basis according to certain priority rules that are listed in the bankruptcy code. And at that point, the business ceases to exist. As a consequence, the business is ineligible to get a discharge under Chapter 7. But now if a business is in Chapter 11, it's going to be repaying the creditors. So unless the creditors accept different treatment, the floor for how much they get repaid is the dollar amount that they would have gotten in a Chapter 7 liquidation. So one of the things we do is list all of the debtor's assets, come up with a dollar value for those assets, and of course come up with a liquidation amount because it does cost money to liquidate assets. And we can come up with then the amount that the creditors would have gotten in a Chapter 7. And so that's the amount that at the very least they have to get paid over the life of the plan in the Chapter 11. But to summarize and answer to your question, no, there really aren't restrictions on the size of the debtor. Really the key thing is, can the debtor propose a feasible plan?